Okay, hi folks, Alex Wood, civil litigator here, vlogging to you on the 25th of June 2019. It's a long time since I did a general vlog on how to bring your own claim in the small claims court in England and Wales. In fact, it was 2015, so it's about high time that I did a refresher, because the most important thing, or one of the most important things to remember, is that the law does change over time, particularly in the area of small claims with the various limits and costs. The government constantly changing costs, so you need to be confident that what I'm vlogging to you is up to date. So check dates on any research that you're doing into the small claims track area, or indeed any other area of civil general litigation. Now, the very first thing I want to say is, if you're bringing your own claim, is there is a Bible on this, and the Bible is now freely available on the internet, of course, and it is called the Civil Procedure Rules, or the CPR for short. There used to be a big white book, but of course, well, there is still a big white book for barristers, but now you can obviously access all the information online. And it's quite important to know that, because if you are a geek who wants to drill into the legal side of things as far as procedure is concerned, then you can do worse and print out some civil procedure rules about an issue you're not clear about and take it to the judge at the trial or an earlier hearing and say, look, X, Y, Z. The judge will have to take any points you make about the civil procedure rules seriously. As far as small claims are concerned, the relevant section is CPR 27. There's the rules, and then there's a practice direction, which is like the guidance on the rules. So now, I'm going to assume that you're not a geek or a law student or a solicitor, and that you actually just want some general advice, because, to be honest with you, even lawyers struggle with the civil procedure rules, I'm afraid to say. Now, the very first thing that I want to say, and I think it's really important that you understand this, is we're not like the American system. As I understand the American system, you kind of got a very specific small claims court. You bring it to the small claims court. You always know it's a small claim and it's a special separate procedure. Well, I can't obviously comment on the American system, but I think that's given people in the UK a certain misunderstanding about how it works in the UK system. It isn't actually a small claims court. It's a small claims track. There are 3 tracks, depending on complexity and claim value, that a claim can get allocated to by the court staff when you file your papers. And that decision of track is a critical one. And just because you think your claim is a small claim, for example, it's in most cases a small claim qualifies if it's £10,000 or under, although there are exceptions: personal injury, housing disrepair, £1,000. Look at the detail if you've got a personal injury or housing disrepair claim, because that 1,000 isn't black and white. But I haven't got time to go into that in this vlog. So, yeah, the court actually allocates it to a specific track. Now, if you get allocated to the small claims track, and more often than not, if your claim value is under 10,000, you will, or under 1,000 in PI or housing disrepair, yeah, fine, you're on the small claims track. It means that even if you lose, you don't have to pay the other side's legal bill. So, you can, even if you lose, you probably will never, even if your claim value is at the high end, have to pay more than £1,000, or probably a lot less. Okay, and that's designed to keep lawyers out of the courtroom, to keep costs low. There are also different procedures. Things are a little bit more informal, but don't think that the law is any different. It's still the same judge as for a higher track claim, and it's still, it'll be in his offices rather than open court, but then a lot of cases are anyway, and there will be certain informality in terms of procedures and protocol. Yeah, fine, but don't get tricked into thinking it's a separate kind of standalone system, and you can bring a small claim and it will always be treated as a small claim. So let me illustrate this really critical point, particularly if you've got a claim value bumping around the £10,000 mark. I had a client a few years ago. She brought her own claim. She got a little bit of legal advice, but then she wanted to do it herself. And she had a claim value of about 15,000, made up of 2 different loans. Yeah, She decided to bring one claim. A lender had lent her small business some money to help with setting up an invention she had for non-drip trays, very good idea. They'd had very draconian and punishing redemption clauses anyway. She sued, and she tried to bring it into a small claims track because she was afraid that the lender would instruct heavy-duty lawyers, and if it went into a higher track, she'd end up having to pay their legal bill. But so she only brought one claim after the other. Yeah, one was just under 10,000, the other was 5,000. And unfortunately, she ran into what's called a strikeout application, in which her opponent said, this isn't really a small claim. It's very complex, there's financial issues. Most importantly, actually, she should have brought these two claims together because they're both based on the same set of facts. Bang. She thinks she's got a small claim. It turns out it's allocated to the fast track, and she's suddenly faced with the fear of a big legal bill if this lender instructs lawyers, and they did. So don't try and trick the system, yeah? And the rules don't say in every case if it's under 10,000, they just say that's the normal track if it's under 10,000. There are other factors the court will have regard to. If there are lots of witnesses, if there's some complexity, financial mis-selling is a classic area in which it might get bumped up to a higher track, then even though it's under 10,000, it might get allocated to a higher track. So be alive to that. That being said, the vast majority of people listening today who've got claims of under £10,000, don't get too worried. Just don't try and be tricksy with that £10,000 issue. Okay, so that is by way of a general introduction. Okay, so critical question: how much is it going to cost? Yeah. Okay, I'm going to give you some broad strokes here. Don't hold my feet over the fire on this if it's slightly approximate. But if you've got a claim at the higher end of that 10,000 limit, you're probably looking at having to find about £1,000, certainly no more, probably less. You've got a court fee of 5%, 4.5% if you issue electronically. That's 500 quid. You may have an expert in your case. Often in building disputes, an expert gets jointly appointed to survey the works. The CPR Part 27 limits that at 750. So you're looking at that. If you win, you get that back, all right? And you get back up to 95 quid's worth of having to take the day off and travel expenses. So you're going to get all those back if you win your claim. Now you want to know, okay, well, what's my exposure if I was to lose on the small claims track? Your exposure is pretty much the same, what I've just said, because you're going to have to end up paying that rather than your opponent. If you take legal advice, if you can get someone to conduct the litigation if you want. You can get a lawyer to run a small claim for you, and some people do. But but you won't be getting your legal fees paid by your opponent if you win. There are exceptions, I'm afraid. There are always exceptions in English law. You don't really need to worry about them too much. I've not, in my experience of running small claims, I've never come across this. But you are allowed to get your costs back if you can prove to the judge that your opponent has behaved unreasonably. And that means proper unreasonable conduct, not just a little bit of incompetence or stupidity or whatnot. Okay, so but for purposes of this general vlog, you aren't going to get your legal fees, and nor is your opponent going to be able to charge you legal fees, win or lose. Okay, so hopefully that is some reassurance. Now you might have to pay a bit more if you lose, actually. Let's say there's a counterclaim, like let's say it's building works, and let's say a builder claims against an individual for an unpaid invoice for works done, and then the individual says, well, as you were lugging your scaffolding pole through my Georgian period drawing room, you crunched into a chest of drawers, and you know that's a priceless artifact, and I'm counterclaiming for damage done to that chest of drawers. You've then got a counterclaim, yeah, and that will, you have, if you're going to file a counterclaim, not even file as a defence, but if you file a counterclaim, there will be a court fee, just as you have a court fee for the claim. So basically, the claim court fee may be slightly higher if you are losing and paying your opponent's costs. But as I say, broadly speaking, £1,000, and obviously £1,000 claim, it's going to, without experts, you know, it's going to be a lot lower. What's 5% of 1,000? It's 50 quid. So that's the position as regards cost. Now, I should just say that there are a plethora of information online about this. I've linked below in the description box forms that will tell you what the court fees are. That's an EX50. You may be able to get the fee waived altogether if you can prove to the court that you are of limited financial means and financial difficulties. You can get relief and go to EX160 for that. Okay, but even if you get that relief bringing your claim, don't forget that you still may have to pay some costs of your opponent should you lose. And again, I reiterate that all that I've said can be found with some little devilish sort of drilling into the legal side of it in the Civil Procedure Rules CPR Part 27. Okay, so now let me come on to the question of, you know, how do you actually bring your claim? Now, the first thing to say is I have done a vlog in detail on how to bring your claim, you know, and draft your particulars of claim. So please, and I'll link that below, please do, if you want some proper help and you've decided to issue proceedings and you want, you know, to know how to draft particulars of claim, go and listen to that vlog. But broadly speaking, you're probably going to be filling in this N1 form, and that's what's called a Part 7 CPR, Part 7 form. It's probably not going to be a special type of issuing proceedings. For example, there is a Part 8 form of issuing proceedings, but this is outside the scope of this vlog. Vast majority of money claims, because again, if you're looking for a remedy other than money, i.e., you know, for the court to order that you have, let's say, a beneficial interest in a property, probably not going to be a small claim, and it's not for a specific amount of money. But anyway, the vast majority of claims are that are around £10,000 are going to be in the small claims court, are going to use this N1 form, and it's Part 7 is the rule. Now, just to come on to the particulars of claim, just keep it really simple. This is when you've got to sit down in a quiet room and set aside your angst. This isn't about grinding axes and getting your own back against a cowboy builder who's, you know, right royally pissed you off. You know, this is quite a surgical, clear-headed, clinical exercise in telling the story of your claim in chronological order with paragraph numbers. If it's a simple claim, you could probably fit it in the particulars of claim box on the second page of the N1 form. You know, on the 5th of May, I instructed Bespoke Builders Limited to renovate my kitchen. Number 2, they quoted me £5,500 for the job. By email of the 25th of July, I accepted this quotation. Number 3, they commenced the works on X. Number 4, they completed the works on da 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 da. They did some extra work, and I was subsequently invoiced. You know, so break it down like that. Most importantly, particularize your loss. Particularize is the word. Be specific about your losses. We're now running a small claims support service, and I've come across this problem again and again, and that's where the client hasn't just sort of done a little spreadsheet and broken down every item of loss and put it into that form. You know, not just the extras that were added by the builder that you hadn't approved, you know, £100, the damage to the chest of drawers, £350, the fact that I had to appoint another builder to remedy the mistakes of the first builder, you know, at £1,750 plus VAT, you know. So you do need, and this is it's very easy to get carried away with, you know, beating the drum about how you've got a great claim and you're in the right. But you've got to be clear-headed about this and particularise the losses. Why is this so important? I'll tell you why it's so important, because there is a risk, and this is particularly the case if you are suing a opponent with deep pockets, like, you know, a public body, for example, or a bank, is they're just going to instruct lawyers whether it's a small claim or a fast-track claim, you know, and they will be looking for opportunities to make your life difficult. One way they can make your life difficult is by attacking your particulars as being poorly drafted, and they can attack them for being wrong in terms of the actual claim value and the particularisation of the losses not being sufficiently clear and comprehensive. Now that's really dangerous, because you could end up, before your claim has officially been allocated to the small claims track, yeah, it's not a small claims court, it's a small claims track, and you have to wait for the court to allocate it to that non-legal cost-bearing track, yeah. They could make a strikeout application early on, and you could find yourself unexpectedly in court the very early days with an hour hearing, and if you're told to go away and bring a fresh set of proceedings or to amend your claim, the judge is likely to order the costs of your opponent against you. Oh, but it's a small claim, you say. Well, you know, perhaps you've watched a little video here and there, or read a chapter in a book. A little knowledge is a dangerous thing. The fact is that until it gets allocated, which kind of happens at quite a late stage, it's after you've swapped your particulars and their defence and their counterclaim, and your reply to their defence and your defence to their counterclaim, the pleading stage, then comes the directions question stage. And at the directions questions stage, if the court thinks it looks like a small claim, it will send you out a small claims directions form. But that's not the end of the story. In fact, an opponent could ask for a hearing just to address the issue of what is the best track allocation. So before it's actually allocated, and a lot of money might have, or a lot of time certainly might have been spent on that pleading stage, the statements of case stage, it is not a small claim, yeah. So so do be careful about that. The other point to make about completing this exercise is do not include evidence. This is not about lumbering the court with a huge pile of papers. You want to put your best points. Let's say they're probably only 5. You know, you want to just simply, skeleton outline, tell the court the facts and the chronology of the dispute so that they can see what the issues are. You know, whether or not your neighbour saw the whole thing and saw through their window a builder smashing a scaffolding pole into your priceless chest of drawers, that should not go into your particulars of claim, because that is a witness, and at a later stage, as it comes quite close to trial, the court orders you to exchange witness statements with your opponent, and that's evidence. So that evidence that the builder writes his witness statement saying what he saw, it should not go into the particulars of claim. I mean, you could write which was seen by a neighbour in the particulars of claim, but you don't, so the court is alive to that issue, but don't put a whole big paragraph basically giving the neighbour's evidence before the evidence stage. Why is it important to do that? I think because people are like, oh, I'm afraid I've missed something out, let's put it all in. I think because a big problem is, and a judge and a court, they're extremely busy, they'll only have scheduled a couple of hours to deal with your small claim. If they can't find your best points because it's basically been swamped in all sorts of random allegations that probably aren't relevant to the issues, because all he's interested in is what's the damage, who was to blame, how much, You know, to be fair, he's not too bothered that you had, you know, 2 weeks of sleepless nights or you had to cancel your holiday. He's just looking at the, you know, nuts and bolts, and he doesn't want to spend time having to wade through a large amount of paperwork. So he may miss your best points if you don't get those particulars of claim done and dusted. Okay, so the next thing is and also don't forget that you're dealing with the courts. It can be bureaucratic. I'm afraid the civil system is underfunded, can be slow, can be very bureaucratic, and you kind of have to hold the court's hand sometimes. So when you are filing documents, you know, make sure that you put the correct things in the subject header of your email filing. Sometimes I think it's actually better to do good old conventional post in these instances. You can include a check. Sometimes you can get into issues of how to pay the issue fee if you do it electronically. And you know, you can actually go to the court and deliver the stuff, can't you? Don't forget that you nearly always have to include 3 copies, because the court will keep a copy. They will send a copy back to you stamped with an issue date, and then they will serve a copy on your opponent. Don't be sly and attempt to ambush your opponent by not telling them that you've issued, you know. Always be copying them in correspondence, and there's absolutely no harm in sending a version of the claim form to your opponent and issuing at the same time, to be belt and braces, yeah. So that is the, hopefully that addresses the nuts and bolts of bringing a simple Part 7 claim. Okay, so here's the interesting question. Should you use a lawyer at all? Question mark. Now, I would say for a low value claim, no. You have got Citizens Advice Bureau. You probably haven't got legal aid, I'm afraid. It's, as far as civil litigation is concerned, very rarely can you access it. You could, there are, although I have struggled to find them, good books on the subject. In fact, I'm going to be writing a book on this subject over the summer and the autumn of this year, so stay tuned for that. But if you have got a low value claim, you kind of want to just be using the very basics and just going online and you know, watching videos. It just is not commercially sensible to be going to a lawyer for an advice for a £500 or even £1,000 claim, yeah, unless there's some bigger principle at stake. And be careful about going to your friendly law students, because they, again, a little knowledge is a dangerous thing. You want someone who doesn't know the law. You want someone who knows the procedure of the law, the protocol, the tactics, the way the court's operating right now. Okay. Okay, but let's say your claim value is 2, 3, 4, 5, anywhere up to 10,000. Well, yeah, I mean, when I did this, the first version of this vlog in 2015, I hadn't set up a small claims support service, but we now have, as a plug for you, set up a small claims support service. And in fact, we run it partly out of Warsaw in Poland, which is why I'm recording this vlog, in order to keep costs down, to make it affordable for you and profitable for us. And you know, again, I've done another video on that, and I'll put a link in the description box below. But I think, I think judicious amounts of legal advice at key stages can help. If you've got a £5,000 claim, getting a lawyer on the phone at the beginning, perhaps about general advice or protocols, and just to talk through the basics of your case. You know, send him a document or two, the letter you sent the opponent threatening proceedings, but you're just on the point of issue. You know, 2 or 3 hours work for a lawyer to look through your paperwork, and perhaps if you want him to draft the particulars of claim, well, that's probably going to be a bit expensive, £5,000, 5 hours work. So in a low value claim, 3,000 not going to be economic sense. But I think it's definitely worth doing it yourself off of advice and videos, and then getting a lawyer to cast his eye over it. And you're looking anywhere between 1 hour and 5 hours work. We we do this kind of work at a discounted rate of 150 plus VAT per hour. As if you've been watching this video, you'll see it's very important you do get your claim drafted correctly. Okay, it's really important. Preparation is key here. So you may well want a lawyer to help you at the initial stages. Thereafter, not so much maybe. Perhaps to cast his eye over the witness statements that you've drafted. Yeah. Perhaps when it comes to trial, a little bit of help just before you go into, scary court for the first time, particularly if your opponent is legally represented. I've got one client now actually, it's quite cool. I've given him 3 hours, I think, maybe 5 hours help with drafting and general advice and how to fill in his directions questionnaire. And then every now and again he pings me an email for query every week or so, and I say, well, you've already paid me some money, so yeah, I'll give you some free legal advice, and it just keeps him going because he's in a strange legal jungle. So I think that in short, that the use of judicious legal advice can help. Where you definitely do need legal advice is you've brought the claim wrongly. I've had a couple of cases, actually civil prosecutions against the police, and it is not a simple breach of contract claim for a broken television or a building dispute. You're now talking about quite complex causes of action, and in both those cases I've had to say, look, you're going to need at least 5 hours work from us. It's not even a small claim in truth, it's a complex fast track claim. And the reason you're going to need advice from us is because the police have lawyers and they have brought or threatened strikeout applications against you because of your poorly brought claim. It's not enough just to be wrong. I'm afraid you do need to play the game, be an entrepreneur, and be tactically smart as well. So where you need to amend your claim, or where there's a danger of your claim being struck out, that's certainly an area, I think, where legal advice is justified, because it's a case of damage limitation, frankly. You could have a court order against you, £2,000, your opponent's legal costs, and a deadline date to file an amended particulars of claim or have your case struck out. So let's just conclude. You may be thinking, after all of that, do I really want to bring a claim? And you know what? Before I was a lawyer, I had a claim. It was against an editor dispute about I paid him some money to edit a short film, and I'd lent him some money to upgrade his editing equipment, and he said, no, that's not a loan. There was more work than I had anticipated in editing your short film, so I'm not going to give you the £2,000 back, which is the money I'd lent him. This is, talking 15, 20 years ago now. And I brought a claim, and I just had to stick at it, and eventually it was listed for hearing. I actually turned up and he didn't show. Surprise, surprise. And I think the key thing is that perhaps once in your life you are going to need to go to court, and you're going to need to do it properly and professionally. And the most important thing to remember is, unfortunately, human nature is to ignore a problem and wait for you to actually take action, put your hand in your pocket and go after them through the courts. It's just simply a fact of life. I try and advise clients to look at this as just a commercial endeavour. Look at your claim value, look at the costs involved, look at the risks, etc., and do the maths. And if you think, no, particularly let's say you're a small business, I encourage small businesses to run at least one small claim a life during the course of the business's life, in order to become a little bit familiar with the legal system in which their business is operating. So I think you probably, and if you're watching this video right till the end, you probably, my advice to you is, what's the expression? Man up and issue that claim. Now, big caveat there is, make sure you have given your opponent every opportunity to settle the matter amicably before issuing proceedings. Pre-action, there's actually a pre-action protocol, CPR Part 7, a general pre-action protocol, which gives you guidance on what you should do before you issue a claim. If you don't do this, you're liable of getting in trouble with the judge. Okay, that's all for now. I hope you find this whistle-stop tour of the small claims track in the UK, at least the England and Wales county court system, of use. If you need help or advice from us, we tend to deal with bigger, more general litigation, but as I say, we have also set up a small claims support and advice service, which is £150 plus VAT an hour, and we've got a website which I will link below with these videos as well as other information to help you with your claim. If you definitely do think you want to get in touch with Redwood Legal, the best thing to do is to send an email to our info address and attach any key documents. We can actually then look at your documents, look at the email and quote you how much it's going to cost for us to help. Finally, please hit the subscribe button. It helps us get up those YouTube rankings and get the good word out to the world. Bye for now.